Now I will discuss in brief regarding the institutions involved in the insolvency process, namely the insolvency professional agencies and the insolvency professionals. The insolvency professionals play a central role in the effective and efficient implementation of an insolvency law, with certain powers over debtors and their assets and a duty to protect those assets and their value, as well as the interests of creditors and employees, and to ensure that the law is applied effectively and impartially. Accordingly, it is essential that the insolvency representative be appropriately qualified and possess the knowledge, experience and personal qualities that will ensure not only the effective and efficient conduct of the proceedings, but also that there is confidence in the insolvency regime. In addition to the requirements for qualifications and personal qualities applicable on appointment, oversight of the insolvency representative, performance of its functions and its demonstration of the qualities indicated can occur in respect of individual cases, though the design of an insolvency law and the respective roles assigned to participants. Insolvency laws adopt a variety of approaches, for example, to the relationship between the insolvency representative and the court in particular, to the delineation of powers between them, as well as to the role the creditors might play in overseeing certain decisions of the insolvency rep and in other issues such as remuneration and even removal from office. Insolvency professional agencies. The Insolvency and Bankruptcy Code of 2016 provides for registration by Board of Insolvency Professional Agencies, hereafter referred to as the insolvency agencies, having insolvency professionals registered with the board as its members. An insolvency professional agency is defined in the code as any person registered with the board under section 201 of the code as an insolvency professional agency. An insolvency agency may be a person which includes the following: an individual, a Hindu undivided family, a company, a trust, partnership, a limited liability partnership, and any other entity established under a statute. The person includes a person resident outside India. A person resident outside India means a person other than a person resident in India. And a person resident in India has the same meaning as assigned to such term in clause 5 of section 2 of the Foreign Exchange Management Act of 1999. Now, can an individual be registered as an insolvency agency? It appears that a foreign entity can be registered as an insolvency agency. Function of the insolvency professional agencies. What are the functions of the insolvency professional agencies? The main functions of insolvency professional agency are grant of membership to persons who fulfill all requirements set out in its bylaws on payment of membership fee, lay down standards of professional conduct for its members, monitor the performance of its members, safeguarding the rights, privileges and interests of insolvency professionals who are its members, suspend or cancel the membership of insolvency professionals who are its members on the grounds set out in its bylaws, redress the grievances of consumers against insolvency professionals who are its members, and publish information about its function, list of its members, performance of its members, and other such information as may be specified by the regulations in this regard. Registration of insolvency agencies by the board. An application for registration to be made to the board. The form and manner, particulars of the application and fee for the registration shall be specified by the regulations. Every insolvency professional agency must have bylaws consistent with the model bylaws specified by the board and the provisions of the code and the regulations framed thereunder. If the board is satisfied that the application conforms with all requirements specified in the regulations, the applicant shall be granted a certificate of registration and under such terms and conditions as may be specified. Otherwise, the application shall be rejected by an order, giving opportunity of being heard to the applicant. Subsection 20 of section 3 of the code defines an insolvency professional agency as is defined as any person registered with the board under section 201 of the code as an insolvency professional agency. Other offences and penalties under section 68 to section 77. If any officer of the corporate debtor within the 12 months immediately preceding the insolvency commencement date is found to have committed any of the offences in these sections, he shall be punishable with imprisonment for a term which shall not be less than 3 years, but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees but may extend to 1 crore rupees or with both. Another provision is a person shall not be liable to any punishment if he proves that he had no intent to defraud or to conceal the state of affairs of the corporate debtor. If or on the insolvency commencement date an officer of the corporate debtor commits any of the following offences, he shall be punishable with imprisonment for a term which shall not be less than 3 years but which may extend to 5 years, or with fine which shall not be less than 1 lakh rupees or may extend to 1 crore rupees or both. Now I will discuss with the cross-border insolvency arrangements with other countries as provided in section 234 of the Insolvency and Bankruptcy Code of 2016. The central government may enter into an agreement with the government of any country outside India for enforcing the provisions of the code. The central government may, by notification in the official gazette, direct that the application of provisions of the code in relation to assets or property of corporate debtor or debtor, including a personal guarantor of a corporate debtor, as the case may be, situated at any place in a country outside India with which reciprocal arrangements have been made, shall be subject to such conditions as may be specified. There is also a provision for letter of request to a country which may be issued. If in the course of insolvency resolution process or liquidation or bankruptcy proceedings, as the case may be, the resolution professional, liquidator or bankruptcy trustee, as the case may be, is of the opinion that assets of the corporate debtor or debtor, including a personal guarantor of a corporate debtor, are situated in a country outside India with which reciprocal arrangements have been made under section 234, he may make an application to the NCLT or DRT, as the case may be, that evidence or action relating to such assets is required in connection with such process or proceeding. On receipt of such an application, the NCLT may issue a letter of request to a court or an authority of such country competent to deal with such request. Now, I have discussed in this module. We have covered the aspects of the various legislative provisions, the legislative framework for the insolvency laws in India. So, corporate insolvency was not basically covered in the Companies Act of 1956. The Companies Act of 1956 only had a provision for winding up of a company if a company is unable to pay its debts. The insolvency procedure was mentioned in just section 529, that in the event of winding up, what will be the priority of payments. In the priority of payments, there were a few conflicting decisions of the Supreme Court. There was a few conflicting decisions of the high courts, and before the matter was put to and rest by the Supreme Court, the various tribunals exercised their jurisdiction, and which led to conflicting results. Now again, coming up to the analysis of the judgment of the Supreme Court. The proceedings under the RDBFI Act had been previously upheld by the judiciary to prevail over other laws as it was a law enacted later in time. While section 529 was amended by the insertion of section 529A in 1985 and workmen's dues preference over other dues, however, the RDBFI Act was passed in 1993 and therefore acted as a priority legislation over the Companies Act. The SARFAESI Act took care of the interest of the workmen through its own provisions by means of an association of the official liquidator with the proceedings before the DRT under the RDBFI Act. Similar interpretation must be taken in context of the SARFAESI Act as well. Another reason for doing so is that section 13 requires notice to the borrower at various stages, which in the case of a company under winding up, being a borrower, would mean requirement of notice to the official liquidator. Now, when the Honorable Supreme Court delivered this recent judgment in 2016, it acted as a major relief by reconciling the SARFAESI Act and the Companies Acts. And ultimate opinion was that thus there is no need to borrow anything from the Companies Act till the stage the secured assets are sold by the secured creditors in accordance with the provisions of the SARFAESI Act and the rules. Thus, the necessary provision of the Companies Act have been incorporated in the SARFAESI Act to protect the interests of the workmen and also achieve harmony between the two acts. In case of the insolvency process has been covered under the Insolvency and Bankruptcy Code, which has provided in detail the corporate insolvency resolution process. The corporate insolvency resolution process has been provided for in the separate module which has been dealt with under the Insolvency and Bankruptcy Code module. So for further details on the corporate insolvency resolution process, the module on the Insolvency and Bankruptcy Code of 2016 may be referred to. With this we come to an end to the module of the corporate insolvency, and for further details and for further information you may also go through the text and material. There are self-assessment questions which are appended at the end of the module, and for further information you are most welcome to consult the respective teachers through the UGC website. Thank you.